These are busy days in the copyright space for sure. In just 1 week, the extremely controversial anti-piracy bills known as SOPA and PIPA were put on back burner by members of Congress after widespread protests on the internet. Shortly thereafter, the Department of Justice moved to shutter the popular file storage website known as Megaupload. Here to parse through these developments and to give us an idea on the way forward, I'm happy to say we have Professor Yochai Benkler. He is at Harvard Law School, and he is the faculty co-director at the Berkman Center for Internet and Society.
I think it's important to recognize that this really was a sea change, the whole of last week, SOPA and PIPA and the protests. It's hard to interpret the timing, since this is the kind of investigation that would take time and an indictment that would take time, but it's very hard to resist the interpretation that this was some kind of message from the administration that on one hand the White House was backing down from SOPA and PIPA, but on the other hand was aggressively pushing forward. Megaupload's not that much of a surprise as a target. What is a surprise is how aggressive the move is, how much it uses extensions of criminal law enforcement and extensions of copyright liability for basically general purpose platforms to go after and seize the assets and seize the people without a full trial, in anticipation of trial. That was a fairly aggressive and expansive move. The industries develop a certain way of making money. Then a new technology comes along. It doesn't matter. It can be the phonograph and sheet music. It can be the jukebox. It can be, most recently and importantly, the VCR. And destabilizes the way that the industries have always made money. And the first gut response throughout the 20th century has been, let's shut down this technology. And copyright law has more or less tried to balance the tension between these two, between the effort to slow down technology so the industry can catch up and our continuous wish and need to develop technologically. And the settlement in 1984 in the Supreme Court case around the VCR was, as long as there are substantial non-infringing uses, the site isn't, or the technology isn't guilty just because the users are also using it for a lot of infringement. For the Justice Department to go after a site that is foreign, that looks and feels like something that is used for a lot of piracy, that doesn't put legitimate uses as its highest and most obvious interface, they picked, I think, the easiest target, the most sympathetic from the perspective of law enforcement target to go after. To go after Dropbox would be the exact opposite. It would be to take something that is so obviously and overwhelmingly a general purpose critical platform and try to shut it down just because it can also be used, and of course it can also be used for infringing activities. So what you have here is a strategic choice of a site that's already pissed the industry off. Any company that in some sense we culturally broadly know is being used a lot for people sharing copyrighted materials is in the crosshairs. But the truth is, the same is true of YouTube. And YouTube isn't in the crosshairs not because legally it's fundamentally in a different space, but because it's already established and powerful. To go after YouTube would be essentially to tell everyone we are going to try to shut down this technology. Viacom did it in a civil suit and lost. It's not that they wouldn't like to shut down YouTube. It's just that they failed under existing traditional copyright. So the Justice Department has moved very aggressively against the next generation of technologies that are general purpose but can also be used for infringement. Had they done the same exact thing to YouTube 5 or 6 years ago, there would be no YouTube, and it wasn't fundamentally different. It's a tempting target to establish a much more chilling basic principle, and that's the core thing to remember about Megaupload. What's chilling here is that a company can be served with a one-sided indictment that lists a whole set of quasi-legitimate and legitimate technological components that lots of other companies use. And by the time it will finish litigating whether that's enough or not, it is dead. Because these procedures for forfeiture during the period of the trial, these will kill the company. And that's exactly what was so dangerous about SOPA and PIPA. What happened last week was that the citizenry of the net, the networked public, became an effective political force in American politics. This is new. It's very hard to see exactly how it will play out. It'll be very important to set for this community, to set for itself a set of discrete, achievable goals. I think the moral authority of a networked public is on a completely different plane than the moral authority of companies paying lobbying, and that's an enormous power to be reckoned with. It's critically important that this enormous new political force be focused on what it is that will build a network that supports the industry in its legitimate needs, not in its overstated fears of piracy, for which there's no real data, but at the same time supports the freedom of people around the net to express themselves, to be creative, to make their own culture and share it.